Okay, I'm going to call the case and talk with everybody a little bit. Good morning. This is case G515892, Avila versus Martinez, with a request to add Olivia, or how do you say it? Oliva, as a necessary party. Counsel, kindly your appearances for the record.
Good morning, Your Honor. Arzu Peruzzi, bar number 10187, on behalf of the plaintiff.
Good morning.
Nasia Avila, who's present.
Soraya Vega, bar number 7944, appearing in an unbundled capacity for the defendant. Rosie Elena Martinez is present, Your Honor.
Welcome.
Stephen Yarmy, bar number 8733. I'm here for Henry Oliva, because there's a motion to add him as an indispensable party, basically.
Okay.
Unbundled, Your Honor.
Good morning and welcome.
Good morning.
All parties, please raise your right hand. Madam Clerk will swear you in, and then you may be seated and relax. Do you have enough chairs over there for? Okay, good.
Sir, I'll need you to raise your right hand. You and each of you do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth. So help you God.
Yes.
Okay, the main thing, unless you guys have a stipulation that we're going to do today, is send both of these guys out for paternity tests.
That's what I was going to come here to ask for.
A return date. I mean, I can't accept the one that he did legally, but I believe it's correct. But the court has to do their own.
Okay, just so you know, he has two tests. One that we attached from January of 2017, and
I
one
have
from
to
July.
outsource the paternity test.
That's fine.
But
he would like the cost split because he's already had to pay for two tests.
well, I don't know about that because you're alleging fraud, and I have some questions of your client. Can you sit down, please? Because the record will show that on February 23rd of 16, they stipulated for mom to have primary physical. March 1 of 17, an amended decree was filed where mom had primary and dad had alternating weekends. And Friday, he also had Tuesday, Thursday, noon to 6. So this is the thing. He had his paternity test January 20th and did not tell anybody or object, or all custody was at issue during that time till that order was filed. So really, I don't have a change in circumstances unless there's actual fraud where she lied to him, and I need to know, Mom, did you ever tell him that he's not the dad, or you didn't know, or what did you tell him?
I didn't know.
Because there was more than one person, right? I mean, did you have a reason why?
No, well, I never knew. He told me like, oh, you knew. I'm like, no, I didn't know. How am I gonna know?
Okay, are you saying you did not know because there was more than one amorous encounter with a male? More than one male?
Yeah, but no, I always thought it was his. Always. Because everybody would tell me he looks like him,
So you truly thought it was his?
Yes, 100%.
Okay, so then my next question is, what is Henry's relationship with the child? Because the law has evolved quite a lot with regard to paternity. A lot of it's through California, but our Love case kind of incorporates the California law, which I think was In re Freeman or something, the marriage of In re Freeman. I have all that information, but I just don't have it right here at my fingertips. Basically, California, after that case, created a statute that says if the child has turned 3, there is no more right to a DNA test. And the reason why is because if a man has been acting as a child's father, the DNA is not the main thing that the court has to look at in terms of the legal parent. The legal parent would be the person who has that relationship. The law is very clear that stability for children is what is the most important thing. So I need to know what kind of relationship Henry has established. If he's held himself out, you cannot be the legal father. You could be declared the bio, but you can't be the legal.
Your Honor, they both lied to my client, both Henry and the defendant. They told him there is no possible way that he's the father. He is the biological father. He's had a relationship too with
I'm
this
following
boy.
the law. He could have come in a long time
That's
ago,
California
even before
law.
the
I
last.
will appeal this.
No. Those are the cases that Justice Shearing relied on when she did the Nevada case. Okay, there's only one Nevada case, so there's not a lot of law, but it's based on California law.
When there's fraud, and misrepresentation.
I'm not
the
hearing.
case
I'm
needs
not
to be-
hearing even an iota of fraud. If she was having sex with more than one man and believed that that was the guy, and they never did a paternity test, and he didn't even ask for one until January, he has to suffer those consequences. There is case law about this type of thing.
He didn't ask for one. He swabbed the child's mouth at a
7
McDonald's,
months ago. I mean, no, it's going to
and
Wait.
that's how he got the swab of the child in order to even get the DNA test done. He's been kept away from this child, lied to for 6 years.
Why didn't he raise it before the last
Because
custody
they
decree?
all
he knew.
said
He knew.
she's with him. They've always both said that he is not the father. And until he saw the child looking like him, he looks like him.
He filed
He-
for the youngest daughter when the son was 4 years old. I think I would have known
Where
this
is the
exactly
clear and
what
convincing evidence of fraud? I'm not seeing it at all.
There's times where he's asked through text message, "Is this my child?" And she said no. Both of
didn't
them have
believe
said
it.
no.
Because she didn't believe it doesn't mean it's fraud.
Didn't believe it. Well, she was the one sleeping with two guys at the same time. What
Well,
do you mean?
that's
That's a red
irrelevant.
flag.
Other than she
would
had the
not believe
reason
it.
to believe it could be either one and thought it was his.
And him too.
That's the only. That's what
So
really
my
kills.
client's going to be punished.
It's not relevant to your fraud case. It kills your fraud case. Is what it
really?
does. Is what
Okay.
I do.
Well, I don't
I think you
believe
guys
so.
need to look at the law because I mean, honestly, I don't know what's going on, but I've had like 5 or 6 of these paternity cases, and then it was like 10 years where I hardly got any. So I don't know why this is happening, but we've had to research a lot around this issue with several different fact patterns. And this fact pattern, you don't even have enough evidence for me to have an actual evidentiary hearing if this man has a relationship with the child.
Your Honor, they don't live together.
That doesn't
They
matter.
are boyfriend and girlfriend on and off.
17
But what's the
years.
relationship?
They've been together for 17 years, Your Honor. If anything,
Not
if
true.
he had he was sleeping with her
How are
when
they-
supposedly if Alan is his son, then he should have brought it up when he brought in the complaint for Jocelyn the second. She's
And
3
Your
years
Honor, they're
old.
avoiding one major issue here. He's been the father of that child the
That's
whole
what I'm
time.
trying to find out.
Regardless if they're married or not, he's been holding himself as the father. So is that really relevant? Do you have to be married to be a putative
No, you don't.
father? So I don't know what that's about, but from my client
He's not the putative. He's the legal. He's on the birth certificate.
So if it became
There's a
that,
statute that
you're
deals
correct,
with
Your
this.
Honor.
They're not
Thank you for
married,
correcting
though.
me. But he's the father of the child,
I'll get the
and that
law.
child calls him dad,
Okay.
and
Well,
has, and always
Your Honor,
has.
they've had an on and off again relationship. They don't live together.
doesn't matter.
My client
Most
is
of the cases
father.
are just like that. Most of the cases are they don't live together, and the person had
He's not been
visitation or
allowed
time.
to
Pardon?
have a relationship with his son, and it's his son.
I get that.
Just like the daughter
he
is
can
his
develop
daughter.
a meaningful relationship because of my understanding from the pleadings is that he has been starting to have time. That doesn't mean that he can't have a meaningful relationship built, but he can't be the legal father anymore because after age 3, it doesn't matter. Bio and DNA is not the way we decide.
Then why
There's
then
no
why
way.
send them out to a
I
DNA
need to look
test
the
or-
law up
Yeah,
because
I'm gonna give you
know
it
what,
right now.
Your Honor. That cannot be possible because if somebody's hasn't known about a child and all of a sudden paternity's done,
What do you mean he
telling
hasn't
me
known about the child? He's the
because
sibling.
they've all said that it's his fault. It's his child.
That's not knowing. That's being told. I was having sex with you. I was having sex with you. I think this is his child, and this one's your child. So that's what she thought. What is the proof of fraud here? Fraud is a tough gig to meet. Okay, I don't know how you're even going to
Let's
get
go
there.
for misrepresentation because there's lies,
There's no-
outright lies made to my client throughout the years.
Your Honor, then why send them out to a DNA test?
He
if
could have
they're
filed a
supposed to be-
motion any time.
Your Honor.
This child is.
He had an attorney. The
5.
attorney he felt didn't appropriately represent him. That attorney was aware of the test. I'm letting you know. I came on as soon as he came to me, and I filed everything I needed to file.
Yeah, and I had a question on what she filed. She filed the motion to amend the complaint, and then she files the complaint and gets the default, which is procedurally incorrect. She had to argue her motion to amend the complaint, and once you grant her motion to amend the complaint, then you file the complaint
She just-
so you can answer.
Yeah, I.
No,
Did
but-
them together.
Nobody actually responded to anything, even though defendant was served, not
This happened
an
when
ans-
I was gone for
That
over
doesn't
2 months.
correct the,
This happened when I was-
Nobody
Hilarious.
answered the complaint,
Nobody
and nobody
answered, so
opposed the
procedural
motion.
error.
I filed defaults, and they've been accepted. So that's where we are.
Incorrectly accepted the
And
default.
affidavit of service has been filed, Your Honor. on
We will not be
defendant.
doing anything with the default except striking it, because
Okay,
the policy
well,
of the law is
I had to
always
do
submit
that.
to litigate things on the merits if people are here. Everyone's here with counsel.
Right.
So what I would suggest, I'm trying to find something I can print that's not tied to another case. That's because these paternity cases are sealed, so I can't just give you all the law unless I remove all the names. What I'm trying.
I would like a chance to brief this issue, because if this is the case, I mean, I'm going to appeal it, because there's no way.
It would have been good for you to research before you came in. I don't think you would have
I did
given him the
research it.
advice that you gave him.
I did research it, Your Honor. That's my due diligence to do that.
Hold on. Let me just. I'm just going to call on because I can't find it for some reason. Never find the 6. Hey, can you do me a favor? Because counsel for dad is not aware of what's happening with paternity law and the DNA testing and stuff. And apparently in this matter, Avila Martinez, Mr. Oliva, he has counsel here, and he's been holding himself out as the child's dad, according to their side of the story. So I need a printout of, remember that memo that was done? I cannot find it on my computer, but I need something, and I need it to have any identity removed from. I mean, those memos are like 2 or 3 pages, I think. I mean, I sent it to you by email, and I thought I saved it with my decisions, and I cannot find it. I don't know why. Okay, thanks. Bye. All right. He's going to bring all that down.
I'd like to have a copy of it too, Your Honor.
Oh, yeah, we'll make a copy for all you guys.
Thanks.
There's quite a bit of case law. I actually went on Westlaw because I was looking for my files for my first term. I'm like, last time I had this really big issue was in between 2002 and 08. I mean, and all of a sudden there's all these cases that people want DNA tests, and the kids are 10 and 12, and you know, some of them no dad has been around. So if they stipulate, then I'm fine doing a paternity test. I am going to send you guys for paternity tests, and there's no reason why, even if Henry is declared the legal father, why dad can't also have a father relationship with the child. I mean, there are a lot of blended families out there these days with more than 2 dads.
Your Honor, but I'm not like denying.
Stand up.
I'm sorry. I'm not denying anything. I just wanted to see my son and my daughter more. The reason why I did a settlement last time is because I didn't want to go to trial, and then I didn't have enough money either. But I just wanted to. I was seeing my daughter at that time. I was seeing her more, almost every day. She never had a good relationship with Henry. Nothing. I'm not saying nothing bad about him, but all I want is just to see my son and my daughter as much time as I can, at least 50-50 or more, because I have the time for it. And I always ask her, "Can I see him?" And
There's not a change in circumstances, because basically the last decree was filed after you knew this. And you're telling me you intentionally decided not to do anything you didn't want to litigate. So you thought about it and said, no, I'm not going to do that right now. So there's not a change. But I can send you guys to mediation to work out something. I think that you should be able to have Alan and Jaslyn, you know, on a regular basis together, because you are their biological parent. But this man, if he's got a relationship with this child and this child calls this guy dad, I mean, that is a huge thing. holding yourself out is really the main thing, and that's also codified. But bottom line, the child is too old unless there is clear and convincing evidence of fraud.
Your Honor, the Constitution protects his right to parent his children, and that law trumps all of this law. So if it's a constitutional issue for him to be
It'd
able
be good
to
if
parent
you
his
read the law
child,
first before you make all these comments on the record, because you're not correct about this, okay? This is law that's in the favor of children and their stability and maintaining familial relationships, especially those that are created when kids are very young, and bonding and trying to learn to trust about relationships.
Your Honor, they're not married. They don't live together.
That is nothing to
could've
do
held
with it,
himself out
and
to-
most of the cases are just people who are not married, okay? You just need to get on Westlaw and read them.
No
But I'm going to give you a
presumption
lot of
that he's the
information.
father
I
just
wanna
because he's
let
on the birth
court know There's
certificate.
also a 10-year-old son she has
Yes.
with him
They're like
that
this.
very attached to Alan, the 6-year-old. I mean, if you look.
What's that child's name and birthday?
Henry Oliva Jr. And his birthday is 11/22/2007.
So he has to be taken into consideration when we want to extend all this time that he wants now,
But
because
could
then
you?
you're pulling away both kids from their brother, and they have a very.
Well, they
close
have to
bond.
think about all these things when
Right,
they
but I just
try to
wanted to-
mediate something. I'm just trying to make it clear. I'm just blown that I can't find this. That the law is really pretty strong relative to this issue, and actually our changes in our guardianship laws also go in this direction. Where would you be saying it runs afoul of Granville versus Troxville, or Troxville versus Granville? I can't remember. Bottom line, now when you're in a guardianship, guess what? If you're the parent who loses, the legal rights temporarily, let's say you did not consent, you fought this, you objected, and it was still granted. To get your child back, you not only have to prove that you've restored yourself to suitability, you have to prove that you are going to be enhancing the child. I mean, let's see. What
Honor,
is it?
we've had this very case in front of you with Mr. Hoffland, which is on appeal at the Supreme Court. You've made 3 decisions on this in my favor with this very issue that you're discussing right now on guardianship.
I'm just saying it's typical in the law. I'm not saying that this is related. What I'm saying is
Right.
it's related to people coming in and saying, wow, what's going on? My parental rights have been taken. And if you didn't consent under AB 319, you have to show not only that all those things that were wrong are corrected, but that the welfare of the protected minor will be substantially enhanced by termination of the guardianship. Do you know how hard that is? The burden is not preponderance. It's clear and convincing.
Yes.
So not only do you have to prove that you're not the problem that you were before, but that you're better for this child, that you can enhance the welfare over the person that's been taking care of the child, because these laws have been made in favor of minor children, not parents.
I understand that that's guardianship, and we're talking about somebody who's not married to somebody else who's
You're
signed a
talking
birth
about things that
certificate.
don't even matter. These things don't matter. You're arguing facts that don't matter. You need
Those
to
are
read
the facts
law.
in this case.
Your Honor,
It's unrelated to the issue of the legal father, married or not. I mean, there is statutory law that says if they got married after the child was born, then that's another fact that goes in their favor. But honestly, there doesn't have to be any marriage for
What I'm
the
saying, Your
same
Honor,
policy to stand.
is that there is a presumption when the parties are married that if the child is his, it's a rebuttable presumption, rebuttable by DNA, and DNA in this case rebuts that. That's if they're married. In this case, they're not even married. They don't even live together.
Your Honor, they have been living together
That's a
for
short-
17 years. For a very short
that's
time,
enough.
they separated. I don't know.
I
if
don't
it
even
was
care about that.
A few months or
If
something
he's
like
kept
that.
a relationship, that isn't even. I mean, it would add to the fact that they're acting as a family. But if he's been holding himself out as a dad living in a separate apartment in another town or city, it still applies. So
So
I just wish I
is he
don't know. what it
paying
is.
child support? I mean, if they don't live together and all this kind of stuff. If he's held
Do you
himself
have
out
an
to be the father,
arrangement
is
for
he
that,
paying?
or you guys are together?
living with the child. Why would he pay child support?
Yeah.
They don't live together. You guys have both told me that.
I didn't say
So he
that.
lives with the
Your Honor,
child
my
and she
client
lives in
told me
another
that.
place?
He did not represent that to me. He's representing that he lives with his child. You can stand up before the court and tell her if that's different or not. You're under oath.
Hold on a second.
Yes, the children reside with me. The majority of the time, they sleep. They have their own room. They live with me. As for her, she also stays the majority of the time with me throughout this time.
So you each have your own place, but you have a romantic relationship and you're maintaining like a family that's in two homes.
Correct.
Yes.
She rented an apartment, I think it was about a year ago, right?
10 months ago.
10 months ago.
It's only around
On and off again
Which is around the
relationship.
corner from his house.
like 3
Table.
minutes.
I think I might have found it. Hold on. It's in my email.
We'd agreed to the DNA test, Your Honor. We don't have a problem with that. We've already submitted one, and he is going to be the father. And, you know, whatever decision you make on this, I'd like it in writing, please.
Okay, under NRS 440.610, the birth certificate's prima facie evidence, okay? Data pertaining to the father of a child is such evidence if the alleged father is or becomes the husband of the mother in a legal marriage. That's a statutory thing. Another statute that applies is 126.051, presumptions of paternity. Subsection 1D is a man is presumed to be the natural father of a child if, while the child is under the age of majority, he receives the child into his home and openly holds out the child as his natural child. Our case that incorporates the California law is Love versus Love, and that's a 1998 case. It has not been overruled, and it states, under the statutory scheme for determining paternity, the district court is not compelled to determine on the basis of DNA tests that a man is or is not a child's father as a matter of law, citing NRS 126.051.121. And the citation for Love is, if you want Nevada's books, it's 114, page 572. And now this is what that case was based on. Shearing grabbed this law from California and put it into her decision. The legislature has made it clear that although it's now possible to determine biological paternity with certainty, biology is not the predominant consideration in determining parental responsibility once a child has reached his or her third year of life. That is in re marriage of Freeman, and there's another case, in re marriage of B, period, like a capital B. And those are, do you want, I have the California Reporter. The in marriage of B is 124 Cal App 3rd at page 531. And in re marriage of Freeman is 45 Cal App 4th 1437, page 1437. Now here's some more law. The state has an interest in preserving and protecting the developed parent-child and sibling relationships, which give young children social and emotional strength and stability. This interest is served in spite of, notwithstanding, termination of the mother's marital relationship with the presumed father. That's one aspect. However, there are a bunch of estoppel cases out there too. And as the estoppel cases demonstrate, although impotent or sterile men may not be subject to the presumption, they may still be required to support children they have treated as their own. So, I mean, this has been challenged in so many ways. Indeed, by way of estoppel theory, impotent and sterile men are subjected to paternal responsibility on the substantially the same basis that we're employing, basically, in applying the statutory presumption, the nature and duration of their relationships with their putative children. Paternity distinctions based on nature of presumed father's relationship with presumed child are valid. Thus, the face of the statute does not create the disparate treatment which would raise substantial equal protection concerns. Biology will only control a determination of parental responsibility for a limited period early in a child's life, and thereafter the predominant consideration must be the nature of the presumed father's social relationship with the child. Then they created a statute. California law, 1980, the legislature added what is now Section 7541, providing for rebuttal of the presumption by blood testing requested within 2 years following a child's birth. At age 3, after 2 years, absent clear and convincing evidence of fraud, basically, or, a material mistake of fact where you were misled and had no, way to correct that in an early time of the child's life, a request for paternity tests may be denied. In the case of an older child, the familial relationship between the child and the man purporting to be the child's father is considerably more palpable than the biological relationship of actual paternity. A man who has lived with a child, treating it as his son or daughter, has developed a relationship with the child that should not be lightly dissolved and upon which liability for continued responsibility to the child might be predicated. This social relationship is much more important to that child, at least, than a biological relationship of actual paternity. Then there's also cases on claim preclusion, which is a defense that prevents relitigating, previously resolved issues. And that can also apply as to paternity and other valid judgments to protect the finality of decisions, that are disrupting kids' lives. One of the cases that is cited within the claim preclusion is the Willerton versus Basham, 111 Nevada, page 10. Basically, I'm not going to go into that, but there's a lot of stuff about guys saying, it's unfair that I'm obligated to support someone else's child. However, there's a balance between that policy interest and the claim preclusions policy of protecting the finality of judgments as it carves out an exception to claim preclusion for previous judgments that were obtained by extrinsic fraud. It's the same idea, but doesn't apply in this case through claim preclusion, although because his name's on the birth certificate, he is the prima facie, that's prima facie evidence of parentage. And then I think, so the whole idea is the security, the support, maintaining the known family structure may include attachment and bond they've developed as family members, which is deemed more compelling than biology. When a man has been standing in the role as a child's father, holding the child as his own, and they have developed an identity as parent and child and as a family. So, unless I hear clear and convincing evidence of fraud, which I do not, then this is the law of the land.
Your Honor, I just asked for a written decision then, because this
You
is...
can write one from what I just put on the record, and I'll certify the question. And they'll say, did you read Love? Seriously.
I've never written a decision from a judge before.
No, it's just you're appealing an order, and I put all the law on the record. Basically, you've not been able to tell me one thing that shows there's clear and convincing evidence of fraud. And he already admitted that he knew about this in January prior to the March decree being filed. He didn't want to deal with it. So basically, he is the perfect example of someone that is not going to be able to come and challenge it. But I'm not saying he doesn't have the right to develop that relationship with his child. I can't find that he's the legal father because I'm sitting here completely chained, unless there's a stipulation, to statutes and case law. The least power I've ever had in my life, okay? You guys can be creative. I have to follow our law. Our statutory and case law is not in his favor. And if you would have read it, you would have known that.
I have read it. That's the thing. I mean, when there's...
You were disagreeing with everything I said, and I just read from case law, several of them. You said the Constitution overrides that. No, it doesn't. That is what I just read. Okay?
Okay. Well, I don't know how you're saying the Constitution doesn't override case law.
The equal protection, I mean, honestly, it's already been determined that it does not apply. And so if you want to find some new case law that's going to override the fraud aspect of this, which is pretty much a national consistent way of looking at it because of the interests and needs of kids, people cannot just sit on their rights like this. When kids are developing, there's so much testimony in these older cases about developmental needs of kids and why this should not happen, because they are depending on you and they are bonding with their caregiver. That is another reason why guardianship law changed and made it harder, because if a person isn't stepping up, they don't just get to come in later and go, I want to do it now. The child is the one that they're looking through their eyes. What is it? How is it affecting the child?
Right, and you need to do what's in the best interest of the child. The child has a which
Best interest is always
My-
important to me. Of course, that's a bottom line always. But the law says that it's in the best interest of the child. After a short time when they're young, basically you cannot. I can deny paternity.
This is a travesty of
Your Honor,
justice,
that's
Your
what I
Honor.
asked you to do
My
today.
client
I don't
has
see
been
any
robbed
reason
of
to
his
have
right to be a
paternity.
father for 6 years.
No, he hasn't been robbed.
He's
He
been
admitted on the
robbed.
record that he knew about this in January prior and decided
And he
not
had
to
an
litigate
attorney.
it.
And he had an attorney at the time who did nothing.
Do the order from today. You can listen to the tape. Write what I put on the record. Write exactly what I put on the record, and I'll certify the question for the Supreme Court. I think it'll come down really fast.
Your Honor, may I add one thing? I mean, I know you discussed ordering a paternity test, but after everything you said here, I mean, I would ask that you don't do that.
I thought they were stipulating to it.
No,
so
I'm not stipulating
stipulated.
that.
Oh, and
I'm
I'd
saying
ask
it's
you order
irrelevant,
it.
and that it's intrusive, and we don't agree to it.
Intrusive in what way? 2 tests have already been done, and he's been
upon the child to
confirmed.
keep doing something like that to a child and confuse the child. If you're listening to the judge, you would know this.
There is
if you
no
had
confusion.
anything in life and
He's
knew
the
life,
father.
you would know this. I
Excuse
know this
me?
from practical experience that when you're with a child and that child's loving you, blood don't matter.
Okay, I'm a
And that's
mother
what
too.
the judge is
I
trying
don't
to tell
know
you, and you're arguing with
why
me
you're
20
going
times.
crazy.
And we can get on with this. We don't want a
He is the
paternity
father.
test, Your
He
Honor.
is the biological father of both of these children, and he deserves his
somehow
rights.
the information that I've said to you is not registering.
It's
You
registering.
keep saying the words
I'm gonna keep
biological
fighting-
father. I just read to you from many cases going back into the 90s that
You said
say
he's a legal father. My client's a biological father. You can't change that fact. He is the biological father.
Yeah, but there's
The
case
DNA
law that says
doesn't
we don't
change
even
it.
have to get a DNA test. If
It
the
says I
child
can
doesn't
deny
look
it.
like
We're
it.
asking no DNA test.
I thought you guys were stipulating to it. That's
No,
why.
we don't.
We
Sorry,
did
Your Honor,
stipulate
about
to
that.
that, and they
But
just
I can
changed their
send
mind.
you guys to mediation, and I think it's important that the child have as many loving caregivers as possible. I mean, kids have enough room in their heart for as many nurturing adults. Basically, I mean, you're.
Instead of these people wanting the father of one of the children to be involved in the life of the other child, they're pushing him away. That makes no damn sense.
I didn't
That's
hear
not
that.
in the best
You see,
interest
Your Honor,
of the.
I think they just, what I heard them say, the only thing I heard them say about visitation is
They
they're
want a
open
DNA
to
test.
talking about it, but they also don't want to disrupt the sibling relationships.
Correct. That's
They want to,
exactly.
whatever
And the
it's going to be, they want to make it.
And the other child is his child, so
Right.
They've been keeping
And the
it
other
away.
one is his.
They're
So
keeping
there's
him
two
away.
that
But
is.
But this is the
Even in their
thing.
pleadings, they said that they were letting the other child go with the other child.
this
while
is-
he was
this is the
visiting.
thing.
Now they're saying
They're keeping him away.
Which one is it?
They're keeping him
This
away.
is, this is the thing, Your Honor. I received a fake DNA,
Wait,
and I asked
you're
him.
under oath right now.
He
and
did. He
Earlier,
received
in your pleadings, you said that you have now been getting visitation with the child, and now you're saying they're keeping the child away.
Yes, they
I
are,
hate
Your
I'm
Honor.
going to testify.
Since
I want him to talk.
Yes, like they don't
What's
let
the
me.
truth? Because you either lied in your pleading, or you're lying now. Which one is it? They're keeping you away, or
talk
you
about
are
this
getting
child
visitation.
separately.
When I want to see him and I have the time for him, they don't let me see him. They make excuses. I mean, I have everything on text messages.
Okay, I'll read from your pleading, I guess, because I mean, it's these
They are keeping
pleadings.
him away from me.
Rule 11 applies to these pleadings, whether a lawyer writes them or the party writes them. Does anybody have it in front of them where that appears? I know it's in there.
Yeah, I read it too. So I'll look for it.
It's like it's kind of like, well, it doesn't really matter now because I'm getting a visitation, but I want to be, get my paternity test or get my declaration.
Not
that
getting
I'm
visitation. We never said he was getting visitation.
Yes, you did. It's on the
It's in there, I
pleading.
read it.
I'm gonna look for it, Your Honor.
It then.
Hold on.
That they were letting both of the two childs at one time, and that was his basis for not fighting the original custody that he got because he didn't want to split the family apart, which is actually defeated by the fact that there's another child that would have been the same reasoning anyway. So I don't know where they're coming from, Your Honor.
I'm trying to find where it
This
says.
motion was filed in November, Your Honor, so it's been a few months. And in the few months that this case has been pending before we've come to this court, he has not been allowed to see his son.
Oh my God, it's not true. I have
Clearly.
text messages.
Stand up if you go.
My client texts her every week and
He
asks.
gets them.
Here it is, page 10. It's on page 10.
Just sit down.
Page 10 on lines It's in the paragraph that's lines 10 through 19.
Which motion is this? Is this
It's your actual verified motion to amend the complaint filed November 1, and it says in the middle,
It says Rosie,
Rosie
did allow,
did, yeah, go
Rosie
ahead.
did allow Ignacio to take both children on many of
that's
the
what I was alluding
visitations.
to.
However,
What?
Rosie did not have to pay for a sitter and had a benefit of keeping the children together. Was not done to make sure Ignacio would maintain a proper relationship with the children.
But
She
it contradicts
thought that was the
themselves
dad.
about keeping the child away from him when they're stating that they were even allowing the other
Okay,
child to see him.
it's been 3 months since we filed this motion. We're talking
should've
about
supplemented
since filing the motion.
Can I have a
She is not
mediation?
letting him see him.
I'm adding Henry to the case because he's a necessary party, but I don't believe that I've heard any evidence of fraud whatsoever. So I'm not going to grant an evidentiary hearing or a paternity test without a stipulation.
The fraud, Your Honor, is that my client was text messaged a fake DNA test that Henry Oliva did, and he received a fake text
When
message.
was that?
He was trying to stand up, please, and talk about
When
that.
was that?
It was last year, Your Honor. No, the year on 2016 when I was going through my daughter's case and it was done with, and I was asking some questions.
Why didn't you ask for a paternity test on that child at that time?
I did ask Henry and I did ask Rosie too, but they said like, no, he's not yours. I would have told you.
Is that true?
Verbally, but then
If you did that, that's fraud, and we'll be having
see
a trial.
that, and I have that, Your Honor. I have that on the text message.
If you actually gave him a false DNA test,
Yeah, but he took one in January. He did a DNA.
Your
test.
Honor.
No, we're talking about
fraud.
about in 2000.
That's fraud. That's definitely fraud. Is it on a text?
I didn't send it.
It's a text
No,
message
Henry,
from Henry.
because Rosie was denying it, so it was a back and forth where I was telling him there was a time when Henry even picked up my daughter because Rosie wasn't there to pick up my daughter. So he showed up, and I asked him, and I said I asked him, and he said to me, ask her. It was a back and forth, so that's why I had to find out a way because I was still paying my lawyer
Where's the
fees.
evidence that nobody's
Your Honor,
attached
he has
that?
a text message
I haven't text
with a
messages.
fake DNA test.
have-
Where is
that
it?
Hen-
Why don't I have a picture of it attached to this motion?
Yeah, that would have attached.
And this needs to be set for trial, Your Honor. We
I
have
want to
me.
see
That's
that.
fine with
Pull
me.
your phone out and show it to me right now. My goodness, I'm not going to set a trial just based on his word. He's been sitting on his rights for over 5 years.
He didn't lie, please. The one who lied is the one who came up with a fake DNA test that says he's the father.
Okay, but if
You waited till all this through the hearing to say this now. I cannot believe that. That is the.
I heard that.
That's the only thing that you've said in this case today at all, or in your pleadings, that is relevant.
Yeah, now we're
because
going-
that is the
That's a-
only way that you can get around this.
And that's a picture.
First, confirm his phone number because that's up there.
What's your phone number?
702-470-7634.
Yep.
And the picture's right there. You could zoom it in if you want.
Okay.
That's the DNA that I received, Your Honor.
Can we look at that too, please?
Yeah, just for a second.
And I'm going to say he's trying to set aside the decree that saying she committed fraud. She didn't send anything.
Well, he'd committed fraud then, and
But
that's
he
why
has
we
not
joined
done
It doesn't
him.
say who the child is. It just
It
confirms.
says
the child.
Ellen though. It doesn't say Oliva though.
It
That's
doesn't say
him
any
sending it.
child's name.
But that has a number. Has his number though.
It's his number. It's coming from him. It's in response
wouldn't
to
make it
his
up.
request for who is the father of this child. He's saying he's the father, and he's sending him a fake DNA test.
It doesn't
Just
say.
confirm.
He doesn't say that, but he does imply that by sending that. But it doesn't have a child's name on it.
It
And
says
he doesn't
Ellen Oliva on the
respond.
right. It says
I
Alan.
submit
It
that
says
that-
Alan.
That's not
It
reliable.
says Alan
It
on
says
there.
Alan on the right side, Your Honor. That's why I knew it was a fake DNA, something that somebody made it, and I wouldn't be lying about this because
It's enough for a trial. It's enough for an evidentiary.
The bottom line is she's saying she committed fraud. She didn't send anything. She did not commit fraud. You can't set aside a decree saying she committed fraud when she didn't.
That's a good point. It wasn't her who did it.
Then how could
Not
you
only
say
that,
she's
Your Honor, it's after they filed the original custody complaint and got an order on that. And he already knew back then he was worried, thinking about it. So now he's thinking about it a year later. Now he's thinking about it now. It's still too late.
I mean, bottom line, she didn't commit fraud.
I don't think,
She
I think
didn't.
that's meaningless.
Well, she
And I'm
committed
gonna say
fraud
that he
by
said-
I would
saying
ask for briefing on that. That whether or not I'm adding him as a party now, but he's not considered a party, for purposes of what happened
I
with
was gonna
regard
say,
to the
yeah,
fraud,
please,
because
yeah.
that happened before, and so you need to research it in a way that you are isolating those cases that discuss whether or not where fraud is a defense, if another person outside of the case, maybe you can find some with this exact issue, commits fraud, can it be imputed to the party?
Your Honor, he's the one who's on the birth certificate. He just presented a
Could you
fake-
please say something relevant to what I just said? Because you're just arguing over and over the same stuff, over and over. Do you understand what I said the issue is that I need briefed?
Yeah.
You can't bootstrap fraud to mom if you don't have proof that she's, inspiring him to do it, conspiring with him, honestly, you'd have to find a way that she is complicit in that fraud.
Correct. And by the way,
I think, unless there's case law.
we do not even know if he sent that text message.
He just
How
confirmed
about
his
we
phone
know that-
number
It doesn't mean he said that I could leave my phone here and you could go out and text somebody.
with a fake
Doesn't
DNA
mean-
test that has his
doesn't
kid's
have a
name on top,
name.
and it does. It says Alan, and it has his name on that DNA test.
I couldn't even
I
see
will
it.
16.2 you guys with that.
Yeah, well,
Why didn't you
I'm
attach it to the motion to begin with? I don't understand that. It predates your motion.
I don't know.
I mean, and then we're all going to be surprised by it at the last
Okay,
second?
you guys just showed up. I didn't get any response to
I'm
a
talking to the
motion.
judge.
I never got an answer to any complaint
Please,
filed
you
in this
own
case,
this room
and
here.
you guys just
Okay,
show up.
Stop.
I'm the
Stop.
one
Stop.
who did everything wrong.
Everyone is going to have a lot of feelings in this case, and just because dad may be the bio dad doesn't mean that that's where all the emotional feelings are lying. He might be upset because he should have custody because he's the bio dad, but he's had 5 years to question it. He's had 5 years to come in and ask for a paternity test. So unless fraud is proven by mom, or you brief for me a way that fraud by a non-party can be imputed to the party, then I will set an evidentiary hearing. So what I'll do is send you guys to mediation, encourage you not to have to pay lawyers to do all this briefing while you mediate, and then if you don't agree on some kind of a schedule, then I would say brief that stuff. But let's try to get them to resolve it. I mean, I don't understand why they... At some point, mom was letting the child go with dad, with the other sibling.
He just saw the child yesterday.
Hold on. So,
5 minutes.
so it doesn't seem to me that this is an impossible situation where both of these men could be considered dad to this child. But this dad would not be the legal father. So if you guys split up and you went for child support, that dad would be paying child support for this child. Do you see what I'm saying? So, and also rights to inherit and all that stuff. But, there's no reason why this dad cannot have a relationship either. And you were already letting him have one. So I'm suggesting that you simmer this whole thing down, because the law is what it is, and facts are stubborn things. So you can go to the mediation center and work out something and walk out of here without a trial, which is going to cost you over $10,000 to $15,000 to put this trial on. Okay? We're talking about a hard thing to prove, and because it's not from a party, I don't think it's going to apply. But I'm not going to say that that's the law, because I've never researched that issue ever. It's an interesting issue, actually. But I would not be doing that for your clients until they try, because these guys do not seem like they have a totally adverse relationship, or mom would not have been sending Alan with Jaslyn. So, I mean, I would say work out something, come each of you with ideas so that not only, dad can have the Jaslyn Alan time, but that, Henry, Alan, Jaslyn, and you guys have your time, that doesn't disrupt the family stuff too much, what you've described.
So should we wait till they go to mediation, see if they could work out some kind of visitation?
Yeah,
for
try to
that?
get an early...
Or they have to hire attorneys, or in our
No,
case, so we could come
Get
in
an
and argue
early
the brief.
get an early date down there, so they can all sit down together, And as soon as they know that they have an impasse, then I would say, yeah, start briefing. And if you want an earlier return date because they realize it's an impasse, then do your briefs and request that so that I can look for a date. Because I have to give like 90 days for FMC, but that doesn't mean that they wouldn't have an agreement prior to that or not have one where you could actually be prepared with your briefs prior to my hearing.
Your Honor, so since they're unbundled, I mean, I'm preparing.
Where do you serve? Who do you want
Doing.
her to serve? Both of the.
She could serve them.
And so both attorneys don't want service until they're hired for the next
Correct.
That's
hearing.
correct.
Okay. So absent, signing off on an order, which if you want to prepare the order from today's hearing, you could do that. Then I would say serve the to the mom and the putative dad, basically.
Can we just get their addresses on the record because I've
Yeah,
tried.
we're going to give it to you. We're going to write it down for you.
Okay.
Right. I want to make sure we're correct in the computer too, and everyone needs to know that 10-day rule applies, which is 10 days prior to changing addresses, work or home, phone numbers, work, home, land, or cell. You need to notify the other parent in writing. Could be text, could be email, and you need to update the family court system by filing a one-page pleading that's called Notice of Change, and it's on the Self-Help Center website. If you don't do that and they serve you at the last known address, sometimes relief gets granted when you haven't really had notice. So you need to be really good about updating your addresses.
Your Honor, my client is given the address of 5729 I can't read
Awakening
that.
Street?
Awakening Street, North Las Vegas, Nevada, 89081. And I've been informed
They should
that
address
that's
her.
the same address for her too, so they can both be served at this address, and I'm handing it to his attorney.
Thank you.
89081.
89081.
That's in North Las Vegas. I've never heard of that one, but
And we don't.
they every now and then create a new zip code. All right.
So we'd also like that DNA paternity test as well.
No, they object. And the law doesn't support it until there's clear and convincing evidence of fraud. So after the briefing, if they haven't reached an agreement, which I doubt that these guys are going to want to pay $10,000 to $15,000 for a trial, I doubt they can even afford it. The smartest thing to do is for you to go sit down and work out a schedule that's in the best interest of the kids. Just think about what it feels like to be them, and put something together that makes sure that you maintain sibling relationships and allows the child to have good relationships with both. If you find that you still want to litigate the legal issue, even if you have a schedule, I may require that he pay some fees up front if he wants to litigate it, because it's been 5 years, and basically, unless you can bootstrap the fraud to the party, it's not going to be. I'm not going to have a case. So I'm not going to have a trial if you cannot show me that is something that's a viable legal theory.
And I just need to brief that issue because that's going to be the issue.
It's clear and convincing. So clear and convincing.
That she committed the fraud, unless there's some case law out there that says that she's guilty of fraud because he did something. And he did it.
Because she's not aware of what if he said anything, she may not be aware of what he said to her, and really,
It's
the
really
issue
got to
between
be.
these two parties
It's
that
got to
have
be her
relationship.
saying, "Do this, send it," because that's her.
And
fraud.
that would have to be testimony.
Fraud
from
requires
her and-
intent.
You know, just
Fraud is a
because he
pretty
said
difficult.
something doesn't alleviate him of inquiring back to the person that he had a relationship with.
So
He
it's
didn't
my
have a
client's fault that
relationship with him.
they just dumped a fake DNA test on him in 2016,
No, it's
and they're
your
acting
Saying
like
they,
they don't
You're
know.
saying they, but it's not on
They
her
live
phone.
together,
Oh,
and
That's not how we bootstrap fraud.
now we found out they live together.
2015,
supposedly.
they moved they were moved in together. In 2016, last year she moved out when I was telling her more and questioning more about Alan, and that's when she moved out of her
Your Honor,
this guy's
in March
house.
of 2017, he filed an amended stipulated decree of custody. At that point, something could have been brought out.
That was his lawyer who drafted that.
Correct.
And so
Something could have been brought
it
out.
can be held against the
I
judge.
believe this is my son. I just had in January. I had a DNA test. I swabbed him at a
He
McDonald's.
decided with his lawyer not to do this. So
Well,
he
he said it on the
purposely
record.
I
decided.
don't know what he decided to do with
He
his
put it on the
lawyer.
record.
Yeah,
He admitted
he put
that.
it on the record.
He said
Yes,
he
Your Honor,
didn't-
but I asked both of them to, we can work it out. If he's mine, let's take a paternity, let's work it out together out of court. And I asked both of them verbally, And they said, no, well, you should ask her. And then her, she's like, you know what, I don't want to talk about this. And that's when she would use my daughter against me a lot. Well, we're just going to go based on the older.
Just sounds like more
The
admissions
daughter
to me,
would
Your
have been
Honor.
2 years
But
old
More
then.
admissions he
I
knew
wouldn't
and
be
did
here,
nothing.
Your Honor.
What?
I wouldn't be here if I didn't know about my son. I found out about my son. I missed 6 years. Yes, I understand what you're saying.
Did you hear what I said about the law?
Yes,
I didn't create that law.
I know, and I understand. But the whole point, Your Honor, is like, I never wanted to come to court in the first place. I wanted to work it out of court to save money for the kids, to be there, not confusing them as much. But all of a sudden, I'm the bad guy here. It looks like I'm the bad guy here.
Well, no one has to be the bad guy if people
sounds
will
like it
put down their
because-
arms and
It
sit
sounds
down and
like
look at
it,
a
Your Honor.
schedule.
Yeah, I think they're going to work something
I
out.
think
We're not
they'll
saying
work
he's a
something
bad
out.
guy. We're just I'm protecting this guy.
They are saying, because they're saying that all of a sudden you come into their, to Alan's life, and it's not that,
Your
Your
Honor,
Honor.
he had noticed.
Well, it's very immature of you to have waited this long because
it's not that,
you
Your
did
Honor.
not say, "Hey, I want another child. I got to find out if this is my child."
I did ask her, Your Honor, when she told me about Alan.
You listen. Ignorance of the law is never an excuse. If it was, everyone would use it. So even if you weren't with counsel, but you were, you had Netta, and she's very smart. Bottom line, when you know there's a child that could possibly be yours, it is your responsibility to come forward fast because that
I did.
child is building
Actually-
such important primary relationships that help base all of their secondary and tertiary relationships on based on the trust that they build with that nurturing caregiver. All right? If a dad was unfit or a dad was, not really involved or just paying child support and not spending any time with the child, those are different things. Those are different cases. This is not that case. All right? And you didn't come in.
Okay, first of all, I did ask Netta during the time that I was already finishing up with my daughter's kids, because that's when I was noticing some resemblance, because I would see Alan and my daughter every Friday because he didn't have school at that time.
But earlier you said, and then at that time I decided not to litigate. That's
He didn't
those
have
are
the
your
money,
words.
Your Honor. He didn't
That's
have
not
the
an excuse.
he Netta didn't bring it up.
I'm sorry
I
that the
can't
law.
do
I have
what
to say I'm
her
sorry
job
for you
her.
guys that the law is what it is, but I've had several of these lately, so I had to do a bunch of research, and I did, and that is what it is. That's the law.
Your Honor, he had noticed he was having sex with her when
I think
she
the
was
judge is
pregnant
ruling
from
in
Alan.
favor.
He
Let's
could
leave
have
it
said, I want a DNA test. When he
did.
asked for a DNA test,
If someone really
Alan
cares
said,
about
"I
raising
want
kids,
a
did
I would
ask.
think that
I
if
did
there was
ask,
a
so-
question, you would get the
I
did
did
ask.
ask, Your Honor, and I was there during the
We're
9-month
talking about
period,
legally
and I
when
did
you-
ask when Alan was born. But then, as a mom, she should know who's a father, right?
No, you don't. If
No,
that's not-
yes,
No.
yes.
No.
I mean, not once, but
What's
twice.
my return date?
Twice.
By that same
Your Honor,
theory, you're on notice. You were on notice too. You
Your Honor,
did it.
when he filed in 2015 for the complaint for
he-
custody, he could have included Alan. He
When
could
you
have-
say I know 6 years has gone by, like it's
I
like,
can't
no
do
big
anything
deal.
for what his previous attorney was doing, but
Yeah,
Well,
but it doesn't
that's-
buy you an
that's
excuse
him.
either,
when he
though.
got a
When
fake
his attorney
DNA
does something,
test,
that's him.
when he got a fake DNA test, in his mind, that was the father. He still could not let
That's
it
still
go.
that's still a long time, and it's after age 3.
That was last
what
in
happened was after age
2016.
3, so it was already too late at that point under the case law. But what you should focus on is going and trying to come to an agreement, and then if there needs to be some counseling, whoever has some health insurance, so that the kids can understand that everyone's not going to be fighting about this. All these people love you. These guys are both your dad. You have 2 dads. You're really lucky. If you do it through a therapist, it'll be a lot better than that I'm the legal dad, but I'm your bio dad. Oh my gosh.
Well, I've
Don't-
been getting that from my son, though.
Well, let me tell you this: if you guys are talking about this to any of the kids or around them, or even on the phone talking
He
to
did.
somebody,
He already
stop.
told them.
Then
did.
I will sanction you. Okay, I'm ordering you not to. EDCR 5301 or whatever the heck it is now. I don't know what it is. It's 5301. 5301 is the new statute, which I don't think it's codified yet, or the EDCR, that says you can't talk about family litigation with kids, and you can't leave pleadings out for them to view, and you can't involve them whatsoever. I'm saying go to therapy to talk about what the family's going to do for a couple sessions or whatever the child or children need, so that everyone can say, we can draw a circle around all of these adults and say, that's my family. These are all the people who love me. You know, this is not an uncommon problem. You just have to become very mature and start cooperating with each other and see the whole scene from the child's eyes, and that's what you will do. You'll do the right thing if that's how you're thinking. Not, I deserve this, I own this, I'm that. I mean, I already read to you what the law is. So go forth, try to come up with an agreement, and our return date is
March 29th at 9:30.
March 29th, 9:30. So take your clients down to the FMC. It's on the left before the handicap ramp. And all the pleadings going forward need to include Henry as a third-party defendant.
Okay.
All right, you guys. Have a good afternoon. And Aruza, you're going to do an order from today's hearing if you'd like, or if you want to wait till the mediation, either way. And then the other counsel will sign off on that.
Okay. They're going to sign off or not sign off?
They can have 7 days to review and sign off on the order. If they don't review and sign off and it matches the minutes or matches exactly what I said on the video, then I will sign it, even if they don't sign it.
Okay. Thank you, Your Honor.
But that's 7 judicial days.
Okay.
Because anything under 11 is